Hello. Maine is experiencing some of the highest levels of foreclosure it has seen historically, in particular in York County. We are here today to talk about foreclosure prevention. My name is Chet Randall, and I'm a staff attorney at Pine Tree Legal Assistance. I am also a member of the Maine Attorney Saving Homes Project, or MASH, a joint project of the Volunteer Lawyers Project and Pine Tree Legal Assistance. Today with me is Andrea, and we'll be talking about foreclosure prevention strategies. I want to emphasize that foreclosure prevention in Maine has many tools that you can use to try to prevent foreclosure and keep your home. Andrea is going to talk for us a bit about the timelines involved in foreclosure. Andrea?
Hello, I'm Andrea Bopp-Stark. I'm from Molleur Law in Biddeford, and I too am a member of MASH, Maine Attorneys Saving Homes. And like Chet said, we do want to talk to you about foreclosure prevention and all the options and strategies that are available to help save your home. The time frame for foreclosure can be quite extensive. You can have quite a bit of time before you actually have to leave your house. The first step is if you miss 3 or more payments, you will probably receive a letter from the lender saying that you have 35 days to pay all the back due amount, or it's called arrears. And if you don't pay that back due amount, then they will start foreclosure proceedings against you. If you don't pay the amount after that 35 days, you may eventually be served with a summons and complaint. A sheriff will come to your door and serve you personally with a summons and complaint. And you will have 20 days to answer that complaint. And the process, I will give you a general overview of the process, and then we'll hit every step individually to give you strategies and options along the way. Generally, if you live in your home and you want to keep that home, you're entitled to mediation in Maine. So once the foreclosure is filed, you get the summons and complaint, you answer it, you say you want mediation, you go to an informational session that will tell you all about the mediation, you attend the mediation, and you try and resolve and prevent the foreclosure. If you can't and mediation fails and there are no options available to you, you still have time. The lender still has to get a judgment against you, and that can take 2, 3, 4 months to obtain through the court. And even after a judgment is entered against you, you have 3 months before you actually have to leave the property. So the whole process can take about a year. And like I said, we'll talk individually about steps along that process. Chet?
Don't ignore the foreclosure. If you are served a summons and complaint by the sheriff or receive a default notice from your lender, be active and be proactive. You can save your home from foreclosure using some of these options if you have income in the household. It's important to know that the forms you need to respond to the summons and complaint served to you by the sheriff are available with the summons and complaint.
That's right. When you get a big packet from the sheriff, it will include on top the summons, and under that will be the complaint. And in that packet is a form, an answer or response form. And if you do if you do live in the house and you want to keep the house, you can check a box that says, I live in this house and I want to keep the house. And you send that into the court, and you send a copy to the other lawyer who's representing the lender. And you will then be put into the foreclosure diversion program, which in essence is the mediation program.
Even if you do not see a copy of the form, the one-page answer form, you can write a letter to the court and tell the court that you want to keep your home, and you will be scheduled to participate in the foreclosure diversion program, also known as the foreclosure mediation program. The first thing you're going to get from the court after you respond to the summons and complaint, either by using the one-page form or writing your own letter, will be a scheduling order, an order or a document from the court setting a time and date for a session called the information session. The information session is extremely important. First, you have to go in order to participate in mediation, but it's also important because it's a great time to learn how the mediation process works, how you can use the mediation process to save your home from foreclosure, and to learn about the options available to you and the resources available to help you save the home from foreclosure.
That's right. And at the informational session, you'll be given a date for your mediation. So you have to go to the informational session to get that date for mediation. After the informational session, you'll have 3 weeks to gather some financial documents and some paperwork that the lender needs to review you for a loan modification or other options, and you'll send that to the court and to the lender's attorney. Then you will go to mediation. At mediation, it's either you or you potentially with an attorney, and we'll talk about that a little bit later. The lender will be on the phone, a representative from the lender will be on the phone. The lender's attorney will be there and the mediator will be there. And at that session, usually the first session, is kind of a way to gauge what information the lender has and what information they need. And they will tell you they have certain documents, they may need other documents. It's a time to figure out what they need and what you need to get to them so they can review you properly for a loan modification or some other option. If you need to get them certain documents still, you can set up time frames within the mediation. For example, you can say you'll get them a document within 10 days and they will get you an answer within 30 to 45 days. So time frames can be set up, but it really generally is a time for you to discuss options and what you need to do to have those options available to you.
When Andrea refers to documents that they may need, what she's referring to are financial documents. Before a lender or creditor will consider you for an option to avoid foreclosure, they need an extensive amount of financial information about you to show them what it is that you may be eligible for. The options that may be available to you to save your home from foreclosure are several. The first and the most common that we see is a loan modification. A loan modification is a permanent change to the terms of the loan that allow you to bring the loan current. A loan modification can include a reduction in the interest rate. It can include capitalization of the amounts owed. Capitalization means they add in to the new balance on the loan the payments that you missed and some of the costs and fees that accrued to the account while you were not able to pay. It may also include extending the loan back out to 30 years or 40 years even if it's necessary to make it affordable. Loan modification is one of the options. Another option could be a forbearance agreement. A forbearance agreement is the opportunity to have reduced payments for a period of time while you get over the financial hardship that you've experienced. Another option, yet again, is a repayment agreement. A repayment agreement would be a process of paying the regular monthly mortgage payment and usually some additional amount in order to get caught up on the loan. Those are the 3 primary options available to you if the goal is to keep the home.
And the loan modification programs that Chet is talking about, there are several different programs. One of the most well-known programs is the HAMP program, H-A-M-P, and that's under the Making Home Affordable program, and it's sometimes referred to as the Obama program. And you can learn about this program at www.makinghomeaffordable.gov. And what HAMP tries to do is get your mortgage payment, so your monthly principal, interest, taxes, and insurance payment, down to 31% of your gross monthly income. That is a very general overview of what HAMP tries to do to modify your loan. There are many requirements and there are many ways they can do that. Like Chet said, they can extend the term out, they can lower the interest rate, they can even put some of the principal at the end of the loan in order to get your payment down to where they consider it affordable. There are also in-house or traditional loan modifications that some lenders provide if you are not eligible for HAMP. And those in-house programs are more complicated. We don't have the statistics or the regulations on those. We don't have a lot of information on those because the lenders don't publish those guidelines. But in general, what the in-house loan modifications try to do, again, is get you to an affordable payment. So they need to see all your financial information, like bank statements and pay stubs, and they will determine if they can get your mortgage payment to a more affordable rate by doing what we talked about with the reduction of interest rate, extension of term, or putting some of the past due amount on the end of the loan.
The HAMP program, or Making Home Affordable, and the in-house loan modification programs or forbearance plans or repayment programs Andrea refers to, are those programs that are often available if if the loan is owned by a private investor or a private lender or creditor. There are other loans that are insured by government programs. Those loans include FHA insured loans or rural development insured loans. Those programs or those insured loans have very special requirements for what we call loss mitigation or foreclosure prevention options. It's important to try to know what kind of loan you have. It's not easy to always figure out, but looking at some of the original documents you got at the time that you signed your loan can help provide clues as to what kind of loan you have. Also, calling the bank or the creditor who collects payments, maybe Wells Fargo, Bank of America, Chase, and asking if your loan is insured by FHA or rural development will help guide you as to some of the options available.
If you do not want to keep your home, there are options to what we call exit gracefully. You can exit the home and leave the home. One thing you want to be very careful about is if your home is underwater, meaning you owe more than what your home is worth. So if you want to sell your home, that would be a short sale. You would sell it for less than what you owe the lender. You would have to put it on the market. You would get a purchase and sale agreement signed by somebody who wants to buy your home. You would submit that to the lender, and then the lender would have to approve that. If the lender approves that, then you can go ahead and sell the house for that amount of money. What you really need to be careful about is the difference between what you sell the property for and what you owe. That's called a deficiency. And in Maine, a lender can come and try and collect that from you. So you do want to try and negotiate a waiver of that deficiency with the lender before you do a short sale. Or just be aware that it is possible the lender could come after you for that money sometime in the future. If you can't sell the property, if you've had it listed at fair market value for 3 months or more, you can ask the lender to do a deed-in-lieu-of-foreclosure. And that's where you sign the deed over to the lender and you leave the property. Again, you have to be careful about the deficiency. If you're in foreclosure, if you've been served with a summons and complaint, you can always consent to that foreclosure. You can say, okay, you can have judgment, but I'm going to leave the house. You can take the house. I'll consent, but I want you to waive the deficiency. Again, being very careful that you're not on the hook for that deficiency when everything is done.
Negotiating to get rid of the home can be as complicated as trying to save the home. Don't expect it to be easier, because it won't be. It's also important to know when Andrea talks about waiver of deficiencies, there may be tax consequences to obtaining a waiver of any deficiency. It's important to consult with a tax expert when making your decision as to whether or not to do a short sale, deed in lieu, or consent to judgment in exchange for a waiver of deficiency. Let me take a moment and talk about the financial forms that you may be required to complete for any part of this process. First, you want to get prepared to do these financial forms. The financial forms are usually available at the creditor's webpage, Wells Fargo, Chase, or Bank of America, for example. They almost all require the same kinds of supporting documents. First, they need evidence of income. Usually, if you're employed, they're talking about copies of pay stubs, typically 2 to 3 weeks. If you're paid biweekly, a month worth of pay stubs. If you receive other sources of income, such as Social Security or pensions, you'll need evidence of receipt of those pensions or Social Security. Either an award letter from the pension fund or the Social Security Administration will be adequate. Also, bank statements to help establish that you're actually receiving the benefit or the income. If you're not depositing that source of income into your bank, you should begin to do so you can help establish proof of the income. In addition, other public benefit programs may provide income that can support a mortgage payment and show gross income, such as temporary assistance to needy families. You just need to be able to prove that you have the income through bank statements and award letters from the source. In addition, you almost always need to provide to the creditor copies of tax returns. Those tax returns need to be signed even if you filed electronically. Typically, they require the prior year tax returns, sometimes two. If you're self-employed, you're going to have to do a profit and loss statement. A profit and loss statement is a review of either the quarter or the entire year-to-date income for your small business. Andrew, do you have any tips on that?
On the profit and loss, like you said, it can either be for the quarter or year-to-date, and it can be very simple. It will show income that's come into the business each month and expenses that have gone out, and then at the end, your net profit. And it can be very basic and simple. People sometimes do get overwhelmed with the profit and loss. And realize it has to be done for every month, too. It has to be a monthly profit and loss, and it can be very basic.
Showing your ability to pay is very, very important. So pay attention to how you're demonstrating that you have income into the household and what that income amount is. In addition to showing income, you'll need to list your expenses. It may be helpful to collect your bills and begin to do a budget. We think doing a budget is critically important for you in making any decision about what to do with your house next. Knowing where your money goes and how you spend it will be important to trying to figure out what you can afford to pay.
That's right. And I know probably a lot of people watching this have tried this process and have tried to do this process on their own many times and have sent in the documents, and the lender has told them either they didn't fill out a document properly, they didn't provide a certain form, and so then they send in that document. And the lender says, no, I'm sorry, now 3 months have passed, so everything is stale, you need to start again. So I think that is a common experience with people who've tried to do this on their own. And I do want to make people aware of the resources that are out there to help you do this process. It should not be this complicated for a homeowner to get a loan modification, but unfortunately it is. And it's very difficult. You're not alone if you've had a really tough time trying to get a loan modification. You're not alone at all. And there is help, whether it's an attorney's help or a HUD counselor's help, and Chet's going to talk about that a little bit now.
That's right. There are community resources available to assist you in trying to prevent foreclosure. And in describing the forms that we've talked about and the documents that the creditor may need, it can get complicated and difficult to make sure you're dotting your I's and crossing your T's on all of those forms. We urge you to reach out to the community resources available to you. There are HUD counselors, and what HUD counselors refer to are Department of Housing and Urban Development certifies foreclosure prevention counselors. Their services are free. We have many of them operating and working here in the state of Maine. For your county, it's Your County Community Action Program. Reach out to them and they can assist you for free with preparation of your financial forms, both just to get an application in for modification or foreclosure prevention, but also to submit forms under the mediation program in the court process. In addition, Pine Tree Legal Assistance is available. Where you can reach us or find us at ptla.org is our webpage. Lots of available resources out there. If you need an attorney, you may also want to contact the Bureau of Consumer Credit Protection. Their number is 1-888-664-2569. Their number again is 1-888-664-2569. The Bureau of Consumer Credit Protection operates a hotline with that number, and if you need a legal assistance, they may be able to refer you, or you can, of course, try to hire your own attorney.
Right, and the question is, when do you turn to hiring an attorney? And I would suggest you look into hiring an attorney when the process just gets too overwhelming, and you've tried and tried and tried on your own, or you don't even want to try on your own. You just want to turn it over to somebody to help you with that process. I would encourage you to look for an attorney who knows the process, who knows the loan modification process, who will help you prepare the documents, who will review those documents with you to make sure everything is consistent and accurate, and then who's going to submit that application for you and follow through on that application for you. Following through every week or 2 weeks to see if there's anything that's needed, to see if there's an answer yet, and to really keep on the heels of the lender to provide you with a response. And if that response is a denial, to be able to advocate for you and to help you to get to where you need to be and potentially evaluate you for other programs you might be eligible for, so that you really need an attorney that knows the different programs and knows what your eligibility might be for those different programs. And I would suggest if you're in default and you're thinking you want a loan modification, you can certainly go to a HUD counselor. A HUD certified counselor will help you with that process, the loan modification process. If it does become overwhelming or you get a denial and you want some advocacy, then you might turn to an attorney. And then if you get served with a summons and complaint and you're in the court system now, you probably do want to look for an attorney. Again, experienced in foreclosure defense, foreclosure prevention. Find an attorney that will be there for you, will advocate for you at mediation. The lender has an attorney. I would highly recommend you have an attorney too if you're going into mediation to advocate for you and make sure the lender is doing what they should be doing to evaluate you for any foreclosure prevention option you might be eligible for.
In addition to the option of applying for and seeking a loan modification, we have to mention the importance of considering bankruptcy. For many households, your expenses and debts are overwhelming. Bankruptcy can be an option to help you avoid the crushing pressure. Andrea?
That's right. Our office does bankruptcy as well. I do the foreclosure prevention work there. The 4 other attorneys in our office do consumer bankruptcy, and there are consumer bankruptcy attorneys in this area that do bankruptcy as well. And most of them provide no risk or no obligation consultations. You can meet with them to see what the option of bankruptcy might look like. It can either help you save your home, or it can help you potentially get rid of your home and not face that deficiency that we talked about earlier.
It's important, and we want to emphasize that even if you have tried for many months to get a loan modification or save your home from foreclosure through some other mechanism, and you have now been served with a summons and complaint that begins the foreclosure process, don't give up. Don't ignore it. Participate. The mediation process is there designed to help you get past the hurdles and obstacles that you may have experienced prior to getting the summons and complaint. Mediation can be successful. Andrea and I have talked earlier today, and our collective experience is that the vast majority, 80-90% of our cases that we work with in the mediation process save homes. Please don't ignore this. Respond to the summons and complaint, and you'll get your day in mediation and access the resources available to you.
Yes. Thank you.
Thank you. All done.